Alrighty, folks, looks like we are live. I'm George, one of the co-founders of Solo Suit. We help people resolve debt lawsuits. Here with my friend John Skiba. John, you want to go ahead and introduce yourself?
Yeah, George, thanks for having me again. John Skiba, I am an attorney in the state of Arizona. I do mostly consumer bankruptcy, consumer debt issues. I defend a lot of debt collection lawsuits. And really, I think how we connected, I have the Consumer Warrior YouTube channel where I talk about all this kind of stuff, debt related, and kind of how to deal with it. So that's mostly what I do during the daytime.
Okay, awesome. Thanks so much for coming on the show. Glad to have you here.
Yeah, absolutely.
All right, folks.
Excited to be here.
Great. So we have a lot of people on the webinar today, on the show. We reserved quite a bit of time for Q&A from the audience, so go ahead and put in any questions that you have into the chat. We'd also love to hear what state you're in. So if you want to go ahead and put in what state you are in, just enter that into the chat right now. Love to see where you're watching from. If you're out of country even, let us know. We've got a few questions that we're going to start off with for John. I'm just going to ask him a couple questions that are going to be generally interesting. And then from there, we'll go ahead and get into your questions that you're putting into the chat already. John, first question here for you. It's an easy one. What is debt settlement?
Debt settlement. It is kind of a basic question, but it's one of those things where when people come to my practice in Arizona with bankruptcy, sometimes people are surprised when I tell them, hey, bankruptcy is not a good option for what you're trying to do, and at least go over some of the non-bankruptcy options. And really, when we're talking debt settlement, we're looking at non-bankruptcy ways to deal with debt, usually where something's negotiated and you're paying often substantially less than what the creditor is claiming is owed to resolve the debt. So, dealing with it as far as whether it's lawsuits, credit reporting, whatever it is, you're paying considerably less than what it is that the creditor is seeking.
Okay, great. And how does that compare to bankruptcy these days? How does debt settlement compare to Chapter 13, compare to Chapter 7 bankruptcy?
Yeah, I mean, when you're doing it, when people think of bankruptcy, they think of mostly of Chapter 7, which really eliminates completely unsecured debts. Things like credit cards, medical bills, personal loans, those go away completely in a Chapter 7 bankruptcy. In a Chapter 13 bankruptcy, you're required to pay back a portion of those debts over a 3 to 5 year period. And that always leads to the question, how much? And there's a lot of factors that go into that: income, expenses, your assets, all that kind of stuff. But the general idea of a Chapter 13 is you're going to pay what you could afford based on this formula that's in the bankruptcy code, and then the balance is going to be eliminated, excuse me, at the end of the Chapter 13. The difference between debt settlement and Chapter 7 and 13, in debt settlement, something's going to have to be paid. Almost never does a creditor agree to just a zero, settlement to walk away, except in very limited cases. And so if you're going into debt settlement, I mean, the positive side is you're not dealing with bankruptcy. It's not on your credit report, but you are going to have to pay something. Also, in a bankruptcy context, particularly in a Chapter 13 and in a Chapter 7, the law in the bankruptcy court is forcing essentially a resolution to the debt on the creditor. They have some choice and some objections, but it's limited. Whereas if you're just negotiating directly with the creditor, it's something where they're going to have a lot of input and a lot of say, and they're going to have to sign off on it before you're going to get any final settlement or resolution to the matter.
Right. Great. So would it be accurate to say, as far as like the amount the consumer ends up paying, Chapter 7 is going to be the least, like you're going to pay nothing. Debt settlement's going to be in the middle, and then Chapter 13, you actually pay everything just over a period of time. Is that right?
Well, I mean, Chapter 13, often the unsecured creditors often truthfully don't get a whole lot. There's kind of a hierarchy of payments in a Chapter 13 where it's like secured creditors like home loans, car loans, priority debts like taxes, child support, spousal support. Those are typically paid in full. And then if there's anything left over, there's a pro rata distribution to your other unsecured creditors. So often I see in debt settlement, you actually end up paying more to the creditor to get individual like credit cards settled. However, the trade-off is you don't have a bankruptcy on your record. It's not something where and you don't have core oversight in your life for the next 5 years. You don't have to pay attorney's fees that usually equal, something like you would pay in a Chapter 13. So there are definitely benefits to settlement as opposed to bankruptcy. And there's also a million other reasons why bankruptcy is not a great option for some people. And settlement's a way to still deal with the debt, avoid the lawsuits, all that, and then get it behind you at the same time.
Are attorneys paid the same way in Chapter 7 bankruptcy versus Chapter 13?
Typically, no. I mean, it varies from state to state. I can tell you most attorneys work on flat fees in the bankruptcy world. In other areas of law, like if you've ever had like a divorce attorney or a business attorney, they bill you hourly. And so you're getting billed every 6 minutes that they're working on the case. In most Chapter 7 cases, they're flat fees where it's just a set price and that covers the entire Chapter 7. Chapter 13s can be that way as well. In Arizona, where I practice, you have the option of doing a flat fee, and then you can bill hourly. Some attorneys, with my Chapter 13s, I do bill hourly. I find it tends to be a better value overall for the client and fair, frankly, to my office in cases that are a lot more complex. So it does vary, but I can say, and it varies widely from state to state. I know, Georgia, where you're at, Utah, I've seen what the attorney's fees are for a Chapter 7 there, and they're much different than what they are in Arizona. So local practice and local bankruptcy courts dictate really what the fees are in that area.
Interesting. Okay. Good to know. Good to know. Thanks for the rundown. Next question here. How does somebody negotiate credit card debt settlement by themselves?
And I think this is where the bulk of settlement takes place. I don't think a lot of people hire attorneys to do it. I know some people will get, people often, I think, kind of misname companies like debt consolidation companies. That's not debt settlement, but they're hiring companies to help them settle. But if you're trying to do it yourself, a couple guiding principles that I tell people. One is typically if you can do some type of lump sum, you're going to get a better deal. If you can pay money quickly, you're going to get some type of better deal than if you're saying, hey, I want to stretch this out over the next 3 years. And then also the second thing you need to do is you need to really be able to articulate, whether it's to the creditor themselves or to the debt collection firm or to the debt collector, you need to articulate why it is that they should take less. Particularly if it's still with the original creditor. Mostly internal collections for most companies, it's 180 days before they charge it off and either sell it to a debt buyer or continue on with their own internal collections. I often see my job as an attorney when I'm negotiating a settlement. I try to get information from my clients to provide to the collector or to the other attorney that allows them to essentially take that to their client and say, look, here's why they should take less. There's job loss. There's a serious medical issue going on. There's 5 other lawsuits that are, my client's dealing with. I also look for things like taxes, if there's tax debt, if there's tax liens, if there's past due child support, because those are kind of little red flags that a debt collector that they know is going to make their ability to collect against you much more difficult. Again, if there's job loss or if your income is Social Security based, Social Security cannot be garnished. And so those are the types of things that I always say you kind of have to walk this fine line. I don't like to give what a lot of collectors want. They like these full affidavits and documents and your bank statements. You're just giving them a roadmap to assets. But I do like to provide them with enough information that they can see, hey, there's real hardship going on here. And that's why this account is the way it is. And then follow that up with some type of lump sum. And we can talk about percentages, how I typically look at it, with a specific timeline that it can be paid. If you say, hey, I can pay $1,000, I can pay it within 30 days, that's a legit offer that they can take and you can expect some type of response to. So that's kind of how I would approach it, is having an idea of what you can actually afford. I call that your settlement budget, and then having some hardship factors that you can articulate or even provide documentation on to get the best deal possible.
Okay, great. And once a debt is settled, how do you avoid paying taxes on the settlement? Or how do you minimize taxes, right? Not evade taxes, how do you minimize?
Yeah, the 1099-C. I mean, I know that's what you're referring to. Is what surprises a lot of people is they settle this debt and they're like, man, I got a smoking deal, and then the next January they get hit with a 1099-C. And the 1099-C, it's a tax form where I believe the cutoff now is $600. If any more than $600 is forgiven by a creditor, then anything above and beyond that can be attributed as income to you. So if you have a $10,000 credit card and you settle it for $4,000 and $6,000 is forgiven, you can get a 1099-C from the creditor for the $6,000 that was forgiven, and that can be used as may have to be counted as income on your taxes. And depending on the amount forgiven, I've had large cases I've worked on where we've had $100,000 credit cards that have settled for 20, an $80,000 1099-C is a big deal. And so the question is, how can you avoid it? One of it is, part of it is the way that, and kind of it goes to the bigger picture. If you're going to settle a debt, my recommendation is don't pay them anything until you get something in writing. I don't care if it's an email, if it's a letter, or whatever it is. Get something in writing that puts down the terms of what the agreement is. You can include in there language that the debt is disputed between the parties and that it's not really debt forgiveness, but it's just a resolution of the dispute. And I should say this, my little asterisk caveat here is that this isn't ironclad, but it's something that you can put language in there that could impact even their decision to send you the 1099-C. By law, they're required to do it. If the debt's forgiven, they've got to issue you the 1099-C. Sometimes if you do receive it, regardless, even if you have that language in there, if you receive a 1099-C, particularly if it's a substantial amount, I often recommend that's the year you should use a CPA to file your taxes, because there is an insolvency exception to that, to this, where if you are technically insolvent, if your debts outweigh your assets, there may be no liability, even if there's a legitimately issued 1099-C. But a lot of it is just in the crafting of it. You may want to talk to the attorney or the collector about this as you're putting together the settlement deal. And it's something that you may get some resistance from them on, but if you can't avoid it and they issue you the 1099-C, that's when you need to have an accountant help you with your taxes to try to minimize that.
Interesting. Yeah, so the 1099-C, right? So the difference between the total amount of the debt and the settlement amount will be added to your income for the purposes of taxes. So you won't necessarily pay like a direct tax on that amount, but it could bump you up into a higher tax bracket, or you might just pay a little bit more in taxes because that will be counted as income.
Yeah, I mean, if you're getting a 1099-C for $800, probably not a big deal. But like I said, if it's a larger account, if it's a $20,000 credit card that you're celebrating because you got this great $3,000 settlement, that might be a downer to get this $17,000 1099-C, and that could push you up into a different bracket. At the end of the day, I say it's better to pay taxes on that than it is to pay that full amount. But it also could be a big hit. May take somebody's refund or something they were expecting, and that's why it's important to get tax advice, particularly if you get a large 1099-C after a settlement. You can't, like I said, you can try to avoid that by asking for some language to be included in the settlement agreement that it is disputed, and this is just a resolution of the dispute rather than a true forgiveness of debt.
Right. In your experience, are collectors quite, like if you settle, are you extremely likely to get the 1099-C, or sometimes do you not get it?
Surprisingly, people don't receive it, in my experience. Like I said, the law requires them to send these out. And it doesn't have to be sent out. I believe they have 3 years to send it. And so every now and again, I do a lot of work against a lot of the junk debt buyers, Midland Credit. I remember one year, my clients were just, because they would copy me on it as their attorney, we just got a big, we would get stacks of mail every day with 1099-Cs. And so they do have up to 3 years to send that to you. But surprisingly, at least from the feedback I get with clients and what I see coming in, it doesn't happen in every situation. Could, and you could see if they've submitted it to the IRS. You could go get a tax transcript through the IRS's website and see what's been submitted in your case. You can do that for free. You just open up an account at irs.gov, and you can get the transcript and see if anything's been filed. But yeah, surprisingly, I don't see it happen in every case.
Okay, that's interesting. That's an important thing to note for sure. If you all are considering debt settlement as a good option for you. All right, let's see. Let's see what we have in the chat as far as questions go. We got a question from Maria. I sent my response in, and court sent me a document to let me know if no further information is provided by the collections team, the case would be dismissed without prejudice. Today is the deadline for the plaintiff to submit the info with the court. If nothing is filed and the case is dismissed, it's my understanding they can file again. What should I do next? I have not received any calls or documents from the collection agency prior to the lawsuit either. Just one letter that was missed since it got sent to my mom's house.
Yeah, I mean, if a case is dismissed without prejudice, that means it can be refiled again, assuming that the statute of limitations has not expired. So, I mean, that's the first thing I would look up, whatever the statute of limitation is in your particular jurisdiction, your state, to see, because the time that the lawsuit was pending, if it gets dismissed, it's as if it never happened. And so you could go back and see what is the statute if they're beyond that. And if they are, then you have a little less to worry about because you're not going to get sued, or if you do, you can get it dismissed. And that's also good, kind of in line with our conversation. Before you reach out to try to settle the debt, you got to make sure it's within the statute of limitations and that there's a real risk that they could sue you. Because if it's outside the statute now, because they dropped the ball and now their case has been dismissed, you either don't need to settle it because the thing's just going to go away because it has no teeth anymore, or two, if you do settle it for other reasons, you need to get a really low settlement. If they can't sue you for it, to me, that's 10 cents on the dollar or less kind of settlement if you're going to settle it at all.
Okay, great. In this situation, as far as I'm aware, is called like a dismissal for lack of prosecution. Is that right? Like basically the plaintiff isn't doing anything on the case, so the judge is going to proactively get the case dismissed. Is that how you think about that?
Yeah, I mean, if there's a failure to prosecute, I just had a case like this recently in Arizona where the case sat there in our superior courts. I mean, it was a substantial case, and the plaintiff, their job, the creditor, they have to drive this thing. They have to push it. They brought the lawsuit, and in my case, it sat there for almost a year with nothing. And eventually, I just went in and filed a motion to dismiss for failure to prosecute that was granted. And so some courts too, you got to look, like I know, like in our justice court system in Arizona, there's even statutes that say, hey, the case has to be wrapped up within 10 months. So I know that some jurisdictions will have limitations on that. These are good things. You can go to the court's website and do some research. You can Google it. ChatGPT is a good place to start with things like this, just to get some idea if maybe there is a limitation. And if they're outside of it, the courts aren't, we tend to think that the courts are monitoring these cases super close. They have thousands and tens of thousands. They're not. You need to be the one that go in and say, hey, look, judge, they haven't done anything on this thing for 10 months. You should throw it out.
Right. What kind of time window do you think before it has to pass before a defendant can bring up a suggestion for dismissal of lack of prosecution?
It will depend on if there is a local rule on it. Like I said, the case that I just did it here, it was over a year and there was nothing. I mean, they hadn't done discovery. They hadn't filed motions. No, there wasn't a motion for summary judgment. They hadn't requested a trial date. There was literally nothing going on. If you do it too soon, if you do it, if the court allows them a year to take it to trial and 6 months into it, you file that, the court's just going to say, hey, get this thing going, or we're going to dismiss. That does have some benefit because likely the court's going to give them some deadlines that they need to meet. I wouldn't be the timelines in a court system are much different than what we have in normal life. Things move, I would say, particularly in civil cases, the wheels of justice move very slowly, and it can take a full year for kind of things to get where they need to be. Even though week to week, it's causing a lot of anxiety for you. So I would probably give it at least a good 6 months, and if there's been nothing happening, then move for dismissal at that point.
Okay, great. All right, next question. Let's see. We got a question here from Aaron. Velocity Investments is suing me again. They had sued me in Metropolitan Court. It got dismissed. Now they're suing me in second judicial. I responded to their complaint and got a request for admissions. I guess they're wondering what to do next.
The request for admissions, so this is part of written discovery. Where essentially the parties are exchanging information. The request for admissions, those are a trap. We got to be careful with those, because in most jurisdictions, if you don't respond to those timely, they can be deemed admitted. So I know like one law office here in Arizona that represents creditors. In almost every case, they file their complaint. Once you file your answer, they immediately kick out a bunch of requests for admissions. Requests for admissions are very simple questions. They're usually yes or no, whether you have to admit or deny it. So they'll have questions like, admit that Velocity is the true owner of this account, and you have to check yes or no. Admit that you owe $6,529, yes or no. And so they kind of set you up. And if you don't respond timely, they're deemed admitted. And then so what often the procedure I see is what this one firm does. They send out the request for admissions. If they don't are responded to timely, they then immediately file a motion for summary judgment, attach those as an exhibit saying, hey, they've admitted everything, case is done. So it's something where you need to look, if it's not in the document itself, you need to look at the rules of civil procedure. Most jurisdictions, I believe it's rule 33, 34, 36, right around there. And see how much time you have to respond to. You need to respond to that timely. Otherwise, it can cause you some big problems.
Right. Okay. Great. We got a question from Eric. Hello, Mr. Skiba. I would like to thank you so much for hosting this QA event, since it's been a tremendous help to me. There you go. Thanks, Eric.
There we go.
Thanks,
Eric.
He's got a little bit of a long question here, but let's see if we can't get into it a little bit. On September 2013, I obtained a judgment in this case stemming from a debt incurred by a family member who needs funds for their business. However, the judgment is currently removed from my credit report. This, among other reasons, has motivated me to handle this case myself using solo suit. The plaintiff is now seeking to renew the judgment, which expired in September 2023. I have raised affirmative defenses with the help of solo suit, including arguing that the debt falls under the statute of limitations, denying ownership of the debt, and pointing out the plaintiff's lack of pursuit. Recently, I received a letter from the court indicating that the plaintiff will bring a motion for summary judgment at an upcoming hearing on April 1st or so. I have a few questions to ask. First, how significant is it that the previous judgment was removed from my credit report in terms of my defense strategy? I was able to make a new credit card with Bank of America.
Well, I mean, the fact that, the credit reporting and liability on a debt are two different things. So it's not surprising to me that it was removed. And I guess I should say this. It used to be that civil judgments would show up under the public records section of your credit report. With TransUnion, Equifax, Experian, there's this public records section, and that's where the judgment would show up. In the summer of 2017, the companies changed the rules. They're having too many problems with wrong judgments being connected to people's credit report. And so they changed the rules and said, basically, a judgment is not going to show up on your credit report unless the judgment has your full Social Security number on the front. And there's no court in America that's going to put your full Social Security number on the front of a judgment. So judgments are pretty much gone from credit reporting. Now, the account may still be up there, and the account, it doesn't surprise me either that would be gone. If this is a 2013 account, derogatory information only stays on there for roughly 7 years. So it would have fallen off at this point, regardless of payment. So I don't think those help the case. It was unclear to me if a judgment's already been entered and then renewed. If that's the case, then statute of limitations isn't going to be applicable. If it's something where they're suing you on a different debt, you can go back and look at the statute. But I get a lot of people who get confused with, once a lawsuit is filed, unless the statute of limitations was, they went too long into it. Statute of limitations, what it governs is the time period from when the account goes into default. It gives you, the creditor, how much time they have to file a lawsuit. If the creditor timely files that, and they file their lawsuit within the statute of limitations, it's no longer a defense. The judgment can be like in Arizona, civil judgments are good for 10 years, and then they can be renewed every 10 years. And you aren't allowed to raise any new defenses, like, that they didn't have the debt or the amount was incorrect or whatever. So I don't know if that answers the question expressly, but I don't know if statute of limitations or the credit report's really going to give you a lot of traction if the judgment's already been entered.
Right. Yeah, and to your point there, John, right, it's a little bit unclear, Eric, from your message. I mean, it sounds like what I'm kind of gathering here is that you, in September 2013, you were sued for a debt and then you lost that case, and there was a judgment entered against you. And then the collector, that judgment got removed from your credit report because it's old, but the collector is now trying to renew that debt. If that is the case, SoloSuit doesn't have like a easy product or the product designed for responding to those kinds of cases or situations, right? For renewal, you're probably going to just need to, ultimately you need like a counter motion or something like that, arguing against the motion to renew, if that's the case that's going on here. But ordinarily, what happens is someone gets sued for a debt, they get a summons and complaint document, and then they use our software to create a answer document and then have that filed in court for them. So there's that. Then Eric's other question. Given he's also saying apparently the plaintiff is offering a motion for summary judgment, so maybe there's multiple cases going on here. So given the plaintiff's motion for summary judgment, what are the potential implications for my case, and how should I prepare for the hearing?
And, summary judgment. Yeah. Oh, I'm sorry.
We'll just zooming back just a little bit, right? So the ordinary flow of a lawsuit for debt is the plaintiff brings a complaint and summons, and then the defendant, which is the consumer, you guys, responds with an answer document, and then after that, the plaintiff might bring a motion for summary judgment. At that point, they might send a request for admissions. That's when like a motion for summary judgment happens, and they're essentially asking the judge to rule against the consumer without hearing the case because it's an obvious win for the plaintiff. So with that said, go ahead, John.
Yeah, the summary judgment, that's another trap. I tell people to be careful because often consumers will view the motion for summary judgment similar to the complaint. It's similar in that you do need to respond to it, but it's the level of complexity to the response is greater. In the complaint, the answer that you're using SoloSuit to respond to that, the court wants to know essentially, is there a dispute between the parties? Do you admit or deny what it is that they're alleging? And you go through each of their paragraphs, and that it can be fairly straightforward. Summary judgment, they're coming in saying, Judge, we don't need a trial. Just look at all our documents and tell us if we win. And you've got to be able to go through and pick that apart. So it's a little more complex. It's actually quite a bit more complex, and you need to be able to go through those documents. And what you're trying to show is that there are disputes as to the underlying facts that require a trial. That's really where your burden is. You're having to say, hey, Judge, look, there's a dispute as to the amount owed. There's a dispute as to whether this junk debt buyer owns the debt or not because they provided us insufficient evidence. You've got to go through and pick those issues apart. Otherwise, if you don't respond, a lot of times I talk to clients that are like, man, I don't know what happened. I didn't respond. We have a trial date. Summary judgment gets granted and the case is over. So you got to be careful and really vigilant on that.
Right. Yeah, that's for sure. Okay, folks, we are half past the hour. That's the time that we normally end. We have a ton of questions on the chat. There's been a lot of people tuning in today. I might try to go rapid fire through a couple of them and answer a few more. This is as good a time as any for our disclaimer, right? Just remember, we are not your attorneys. I'm not an attorney. John is a licensed attorney, but he's not your attorney. This isn't an attorney-client relationship formed on this webinar. It's not legal advice. We're just doing a webinar. And then with that said, let me jump in and see if I can just do a lightning round on these questions. Aaron's asking, any guidance on responding to requests for admissions and discovery? Yeah, you can take the document. You can actually email us at support@solicit.com and request a Google document of your answer document, and then you can edit that to fit a response for discovery or request for admissions. And basically, you'll just want to draft, a basic document responding to those documents. Let's see. We got Aaliyah. The judge denied a summary judgment. They didn't have an affidavit for the original creditor. That documents record were properly kept. Schedule trial, what should I do? So if you have a trial scheduled, just make sure that you show up to that. If you have any documents that have been filed in the court, make sure you respond to those documents ahead of the trial. Calm relaxation. I just completed, let's see, doesn't look like there's a question in there. Seems like the plaintiff's attorney is taking this personal because I refuse to accept the 1% discounted settlement offer and send one of my own for 10% of what is allegedly owed. Yeah, a 1% discount on the total amount isn't really what I would call a settlement. He can certainly continue pushing for something better than that. The average settlement amount for a debt lawsuit, in our experience, is about 85%. We're seeing about 71% on our platform. John, do you have like an insight on that as far as like what active debt lawsuits actually settle for?
Yeah, well, I mean, to me, it depends on a couple things. It does depend on whether it's an original creditor, like American Express, they usually bring their own lawsuits, or whether it's a junk debt buyer. Junk debt buyers like Portfolio or LVNB funding, they don't have as much skin in the game. They paid less, and so they'll often accept less. And it depends on, to me, the biggest thing is kind of some of the underlying facts, like we talked about earlier. If someone comes in and they're on Social Security and they have 5 other lawsuits and it looks like bankruptcy is imminent, they might take less. My rule of thumb is maybe on average across the board, 50-60% of the total balance. I've seen them with debt buyers as low as 15%, but then like original creditors, American Express, Bank of America, some of them are 80%, or American Express. They're the most difficult, at least in Arizona. They don't take a huge discount, but so it kind of depends. But I think you're about, when you average it out, I think it's about what I see too.
It's interesting. It seems like the most difficult party varies from state to state. In some states, I hear people saying Discover is the hardest to get a settlement.
Yeah, they don't sell a lot of their debt either. So the original creditors that they're pursuing it themselves, they tend to be more aggressive because they have a better chance of winning their case than a debt buyer does.
Right. Okay, question from Tony. I'm being sued for a debt from back in 2010. Can I claim that this interest and late fees are not applicable because of the origination of the debt back in 2010? So if you're being sued for a debt in 2010, the first flag that raises is, has the statute of limitations expired? I don't think there's any states that have statutes of limitations over 10 years. So the statute has probably expired and you can bring that up as a defense. Let's see. Maria, in Kansas, if the credit card company does not proceed with the case, is it safe to assume they don't have proper paperwork? If so, can I get it removed altogether? Yeah, to get it removed, you probably want to wait a while, but you can file a motion to dismiss for lack of prosecution, or discuss with the judge trying to get them to dismiss the case, essentially for lack of prosecution. Grim, what are the benefits of arbitration? If you have an arbitration clause in your loan contract, which is pretty common in credit card agreements, you can file a motion to compel arbitration, which will require the collector to pay for arbitration in most cases. and will bring the case out of court, making it more difficult to collect, and also giving you a more fair process if it goes forward in arbitration. A lot of people use that as a way to get leverage to settle. Collections called me on debt that wasn't mine. Sent demand letter for data and metadata records. Nothing sent but billing statements. 2 years passed and no lawsuit, but still on credit report. What should I do? You got a real quick answer on this one, John?
I mean, if it's not your debt, I mean, I would dispute it. I mean, you can go into all three major credit reporting agencies' website and dispute it through there. The way that works is they have, it's roughly a 30-day turnaround time. I've disputed things on my own credit report, and most of them will give you even updates weekly, if they receive anything. If the creditor doesn't respond, by law, they're required to remove it from your credit report. If they do respond, then they're going to provide you with that information because they have to be able to justify what it is. If that doesn't work, and it's a legitimate thing, that you may want to look up we call them FCRA lawyers, Fair Credit Reporting Act attorneys, because then you may have a claim under the Fair Credit Reporting Act. But one of the prerequisites to having a claim under the FCRA is you actually have to file the dispute first. So that's a first good step, regardless of what you end up doing with it, just to see if you can get it dealt with that way.
Right. Okay, that sounds great. John, thanks so much for coming on the show.
Yeah, thanks for having me. It's always fun to go over these questions and talk to the solo suit people.
Yep, so. That sounds great. And everybody listening in, thanks for coming. Always remember we're here in your corner. If you're in Arizona and you want to sync up with John, you're welcome to do so. I believe we posted his website here in the chat. And thanks for tuning in. Until next time, take care.